Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In the fifth semester, after the CPC, we have discussed the Limitation Act. The Limitation Act, which provides the period of limitation for so many, in so many articles, we have told you. Of course, you all know, easement 20 or 30 years, then adverse possession 12 years, even the execution petition 12 years maximum period, and in summons case, that is in the so-called summary trial cases, the maximum period is only 10 days to appear before the court after receiving the summons and things like that. There I told you, Schedule 2, if the limitation period is not prescribed anywhere, then reasonable time has to be given. This is once again, once in a blue moon, such incidents do occur. Normally, limitation is prescribed for almost all cases, 99%, but 1% chance is there. If the limitation period is not prescribed, then reasonable time, depending on the facts of the case, should be allowed. This is what is stated by Honorable Supreme Court of India, two judges bench, Justice Abhay S. Vokha and Justice Sanjay Karol, in the case of Messrs. Northeastern Chemical Industries Private Limited and another versus Messrs. Ashok Paper Mills, Assam Limited and another. So, in this case, 2023, the judgment has come very recently. I think yesterday only the judgment was given by the two judges bench. If you know the facts of the case, it will be easy for you to appreciate why the limitation period is not given in such cases. Here, it is a contractual agreement between Northeastern Chemical Industries and Ashok Paper Mills. So, Ashok Paper Mills, they have to supply they will get the chemicals from the Northeastern Chemical Industries, and they have to pay money to them, to the Northeastern Chemical Industries. Because paper mill process, definitely they need some chemicals along with the pulp. Now, actually they paid something, but after some time, maybe in the year 1990s, the paper mills were declared as a sick unit. Right? Paper mills were declared as a sick unit. And it was declared as sick as per the Sick Industrial Companies Special Provisions Act 1935. But you can't keep it like that. Just like our Sirpur Kagaz mills, like that. So now the government of Assam, they wanted to give some regeneration. They wanted to restart the industry. Therefore, first they declared the Ashok Paper Mills under Acquisition of Transfer of Undertaking Act. They have wanted to take away the paper mills into the state control. So by using, that is Jogi Ghopa Act. Jogi Ghopa Act, this is Assamese language. That means they can acquire the transfer of the undertaking. Right. Now, the government has wanted to take over the same. But the Ashok Paper Mills, they have to pay an amount, maybe some ranging of some lakhs to Northeastern Chemicals. So therefore, they have filed a civil suit under Section 16 of the Jogi Ghopa Act 1935. They claimed 1,58,375 rupees together with interest. A commissioner will be appointed to settle the issues under this particular Jogi Ghopa Act. Right? So, the commissioner of payments is called, his designation is Commissioner of Payments. So, he awarded the principal, that is 1,58,375, but no interest. No interest is allowed. Then they approached Northeastern Chemicals, they approached the High Court. High Court held that interest should be paid from 23/9/1992. because interest is delayed. Interest or delay payments to small scale and ancillary industries. That is also some act is there. Anyway, they have to pay some interest from 1992. But on 13/4/2005, the Commissioner of Payments he has given orders that no funds are available and no funds need be paid to them. So against the order of the Commissioner, they have approached once again the district court. They filed an appeal against the order of the Commissioner before the district court under section 22 clause 8 of the Jogi Ghopa Act. Commissioner, the lower court, definitely they have, because there was a heavy delay, they have filed a petition for condonation of the delay under section 5 of the Limitation Act 1963. Right, the chief judge allowed the appeal and he stated that no specific time has to be is there in the Limitation Act, therefore he is convinced and he has taken up the matter. So agreed by this, the other party, they approached the Supreme Court. So review petition. So now Supreme Court clearly held that since no limitation period is prescribed in the particular act of Limitation Act 1963, definitely the court can consider the facts and circumstances and feel if it is within reasonable time, allow the appeal. No, if not, no. Here, yes, there is some genuine legal problem, so therefore the appeal is allowed. So what you have to learn from this is there are certain articles which are not prescribed in the Limitation Act. For that, reasonable time will be given basing on the facts and circumstances of each case. If you know this much, it is sufficient. So please read the case law and enrich your legal knowledge. Thank you.